Foreclosure Alternatives by M. Hedayat and Associates, P.C.
Hello everybody, I'm Mazyar Hedayat, attorney from M. Hedayat and Associates, P.C. Welcome to the first of our community service seminars. This is Foreclosure Alternatives. And we're at Rasmussen College, Romeoville. And to my left here is the big board. I know you can't see it where you're watching, but that's okay. Let's get started with some foreclosure alternatives. First and foremost, foreclosure. What is it? As illustrated here, it's a process for executing on real estate collateral under the Illinois Mortgage Foreclosure Act. Traditionally, foreclosures take about 9 months from beginning to end. These days, of course, in this economy, about 24 months is not surprising. They can still go faster, but there are plenty of foreclosures that take that long. Now, what we said to describe a foreclosure was that it's a process for executing on real property collateral, which is a lot of legal mumbo jumbo, which really means somebody has lent money, a bank, and the collateral is your home. And ultimately, when the bank isn't getting paid, its only alternative is to take the home. So, are there exceptions to this 9-month, 24-month time frame? Yeah, commercial property. Generally, foreclosure on commercial property is much faster. In addition, investment property, which means non-owner-occupied residential property. So, if you own a little restaurant, if that goes into foreclosure, that'll be a fast process. Or if you own a house that you rent to others, same deal. Now, one thing we should note at this point, there are basically 2 kinds of states when it comes to foreclosure. I'm talking about states in the United States. You have states where a judge gets involved in a foreclosure, a judicial foreclosure state, and states where the judge doesn't get involved, non-judicial foreclosure. Michigan, for example, is a non-judicial foreclosure state. Things go much faster there. But for homeowners, it's a benefit to live in a state like Illinois, which is a judicial foreclosure state. And as an attorney, I can tell you from nearly 20 years of experience, it's very beneficial for the homeowner. Now, let's take a look at the steps in a typical foreclosure, what we've labeled here the road to foreclosure. Step 1, of course, the default. Somebody falls behind on payments. Honestly, we could spend a lot of time talking about a default. Suffice it to say, default begins the minute you're either behind on a payment or you pay less than 100% of the payment. There are many people who can pay all but, say, the last 10% of that payment. And in years gone by, it hasn't been unusual that the mortgage company will let you do that, let you even catch up the next month. That's not happening anymore, especially in a judicial foreclosure state like Illinois. You have to pay 100% of what you owe, and you have to pay it on time, maybe with a grace period. But you go beyond that, you're technically in default. After the default, and let me emphasize this, what looks like a very short period here can be very long. The mortgage companies, they all have their own policies. They have their own way of dealing with defaults. For some of them, it's a big deal. I've had clients who tell me that they've essentially been in default, directly or indirectly, for several years. How? By falling behind. 1 payment, maybe even 1.5, 2 payments, but the bank keeps taking their money. That's a decision on the part of the bank. So this period between default and a foreclosure complaint, which is the next thing we illustrate here, could be fairly lengthy. But eventually, when the bank decides that it has no other way of getting paid, it will bring that foreclosure complaint and summons. So that's step 2. Step 3 is that the bank looks for some kind of judgment. What we have illustrated here are 2 basic kinds of judgments, the default and the summary judgment. Default judgment basically means you've received notice of a foreclosure, you've received a summons to appear in court, you haven't done it. Not unusual. After all, if you're behind on your payments, it's hard to explain that away. Either you've made your payment or you haven't. A lot of people simply do nothing, they default. For those who do choose to hire an attorney or go themselves to fight a foreclosure, maybe because they want to make an explanation, maybe because they believe that their situation is different. The sad fact is, again, based on the mortgage document and the promissory note that they signed, chances are the case is all but over. That's called a summary judgment. So you go from a default to a complaint and summons to a judgment of some kind, whether it's a default judgment or summary judgment. The next logical step is the order for sale. Now, order for sale is what it sounds like. It's the foreclosure judgment. Now, many people think, mistakenly, that a foreclosure judgment is sort of the be-all and end-all. When a foreclosure judgment comes down, it's over. No, far from it. Let me point something out. Here, running the length of this process from default all the way through to the sale is what's called, in Illinois, the right to redeem. Again, Illinois is a judicial foreclosure state. They get the courts involved. They also have protections built into the Illinois law. It doesn't go in every state. One of the protections built into the law is this right to redeem, which means if you're a homeowner and you're behind on your mortgage, you can get back on the horse, that's the best way to describe it, by paying exactly what you're behind, plus expenses, plus attorney's fees. It's a small amount compared to your mortgage, say $20,000 on a $250,000 mortgage. Problem is, who has $20,000? We'll get to that later. So the right to redeem runs all the way up to the order for sale. If nothing happens to change that, the sale takes place, and this is known as a foreclosure sale, or more commonly, a sheriff sale. Why? Because usually the sheriff conducts it. And again, in some states, it literally takes place on the steps of a courthouse. It's like an auction. People show up, the bank is there, the sheriff is there. The bank says, listen, we're owed this much money for this house. If you think you can pay us that much or more, we'll give you the house. And once upon a time, certain people would go and then actually buy. Not so much these days. People don't have the money, or for various other reasons, they think they can get a better deal. So what happens is a lot of real estate that goes all the way through this foreclosure process ends up getting taken back by the banks. And once it's owned by a bank, real estate becomes known as real estate owned by the bank. It's very creative. REO property, real estate owned. REO property is a whole separate subject, and it's thanks to people like Lonnie Miller here, who's in the business of short sales and selling property, that REO property moves through the marketplace. Okay, so you've gone to sheriff's sale. Now, as I said, a simple foreclosure judgment is not the end of the line, but neither is the sheriff's sale. Okay, just because your property gets sold on the courthouse steps or whatever, doesn't mean it's over. You know, what happened in that sheriff's sale still has to be confirmed by court. A report has to be made of that sale. The report of sale has to be presented to the court, and the judge has to say, okay, that was fair. And if you're really aggressive, or I should say if your counsel's aggressive, he or she may be able to block that from happening. Now keep in mind, a lot of things have happened. From here to here, as I said, it used to be around nine months. These days it's not unusual if it's 2 years. And still, nobody's out of their home, okay? In fact, title to the property hasn't even transferred. You are still the owner. As ridiculous as it sounds, you could be 2 years in default, and your homeowners association or your condo owners association could still knock on your door and say, sir, you owe this month's assessment. And you're thinking, gee, that's funny, I haven't paid my mortgage in 2 years. But it's still your house. Good or bad. That means if there are violations, if the grass is too tall, if the windows are cracked, if it's a public nuisance, it's still your issue. Okay, you've gone all the way to the confirmation of sale. If nobody objects, the sale will be confirmed. In fact, the judge has to. About 30 days after the confirmation, that's when a bank usually takes possession, and right around that same time, they record their foreclosure deed. And that's when the property really ceases to be yours and it becomes REO. It becomes real estate owned. As you can see, there's a lot of play in here, okay? So for those people, and I've had many clients who are in this position, for those people who think that the notice of default is sort of the end of the line, it's anything but. Okay, thank you for waiting, and we're back with foreclosure alternatives, the foreclosure process. Now, this next part of the presentation doesn't involve so much of me talking. It's just an example of the kind of terms that are going to get thrown around. Now, if you work with a good attorney, someone who's willing to spend time with you and provide you with information you need, you're going to learn these terms, and I just listed some of them here. For example, default. As we talked about before, default is not the end of the line, far from it. In fact, in Illinois, default is a 3 strikes and you're out proposition. What do I mean? Strike 1. Once you miss a payment, yeah, you're in default technically. But at that point, your lender doesn't have to do anything because maybe it's a misunderstanding. Maybe the check got crossed in the mail. On the second missed payment, then your lender has to notify you that you have 30 days to set things straight. On the third missed payment, that's when your lender can say, you know what, this is serious. But they still have to tell you, hey, listen, we're going to get serious on you. We're going to get a lawyer, and we're going to take this to another level. Now, these seem like very minor things. And oftentimes they are, because when someone is in that sort of shock mode, they're not really paying attention. But this is as close as you can come through the law to making a mortgage company get your attention. Make the mortgage company reach out to the borrower and say, hey, do something now before it's too late. Okay, let's say that those warnings don't work. Service of summons. You know, you have to be served before you can be the subject of a foreclosure action. Usually that means somebody coming to your house, a sheriff, or somebody appointed by the sheriff, coming to your house and giving you a copy of the complaint against you. For many people, this is actually a rather disturbing process. In an extreme case, let's say you've been very good at avoiding service, the fact is service can literally be mailed to your front door or simply published in the newspaper. Okay? But one way or another, you have to be notified that there's a lawsuit out there to foreclose. Summons has to be served. There's a foreclosure judgment, an order of sale. We talked about that. Reinstatement. Reinstatement is the process of getting back on the horse with your mortgage company. Okay? It basically involves paying what you're behind, plus attorney's fees, interest, things like that. And then there's redemption. Redemption means paying everything. So if you have an extra $250,000 lying around, you too can redeem your mortgage. What most people really do when they redeem is they're going out and they're finding a new lender. The judicial sale, as we discussed, is also known as the sheriff's sale. Confirmation we talked about. Confirmation means that a report of the sheriff's sale has to be taken to a court. And these are all the steps that have to take place in a judicial foreclosure state like Illinois. And of course, during this entire time, at virtually any point, you have an opportunity. Let's say your, Uncle Lars leaves you some money, you strike gold, whatever. You come into inheritance, or you simply find another lender. At any point, you can take care of your existing lender and get them out of the picture, and foreclosure is in your rearview mirror. That's assuming, of course, this foreclosure didn't come at the tail end of a lot of other debt-related problems. Because once the problems start, you may not be able to get new financing. Frequently, it's a problem we run into. Now, finally, here we have this feature called special redemption. I'm not going to tell you about that because it never comes up. Okay, welcome back once again. Our next panel, we're talking about what I refer to as financial self-defense, foreclosure judo. What to do once you're in foreclosure, okay? It's not something we want to have happen, but if it happens, what do you do? All right, a few simple steps. Conduct an honest no BS assessment of your income and expenses. Okay, this is not the time to be optimistic. Be realistic. Even if you can afford the monthly mortgage payments, if your house is seriously underwater, you need to think about the long-term value implications of staying there. On a practical level, things like school-age children, staying in that school district, and this is especially true in areas like Naperville, Plainfield. These are very good school districts. People want their kids to stay in those school districts. So they certainly don't want to leave if it involves, if it involves pulling the kids out of school before the end of the year. And even if it is at the end of the year, they want consistency for their children, which we can all identify with. And then finally, you have to ask yourself, are you interested in something else? Okay? Whether it's a deed in lieu of foreclosure, whether it's a short sale. At the end of the day, this is not good news, but it's a reality. Look around any neighborhood, any middle-class neighborhood. I won't speak for the. It seems like the rich get richer, but that's not what we're talking about tonight. Look around any middle-class neighborhood. You will find one or two or three or several foreclosed homes, good homes, homes that you'd be happy to live in, but because they've gone through the foreclosure process, it's kind of like a tightening up. These homes are now valued at more or less what they should be valued at. Maybe one time they were valued at this much, but they're only worth this much. Well, now they're valued at what they're really worth. And you could probably move into one of those as a rental or rent to own for less than you're paying now. You stay in the same area, same school district, many times the same neighborhood. So these are the kind of questions that you have to ask yourself to get mentally prepared. Then we dive into a list of alternatives. We have your conventional sale. We have your short sale. We have your deed in lieu of foreclosure. You have your Chapter 13 reorganization. You have your Chapter 7 liquidation. Each of these things means something different, and we don't have time to go into them in detail, but the long and short of it is this. A conventional sale is what it sounds like. You're selling to somebody, you're getting rid of the mortgage, and that's just one headache off your plate. A short sale is very much like a conventional sale, except that the amount of money you're getting for the house is so reduced that it literally doesn't pay off the mortgage. Most people expect to get enough to pay off the mortgage and profit. Well, in today's market, it's not unusual. I'll take an example with real numbers. If you have a $200,000 house and a $150,000 mortgage, it's not unusual that you may have to sell the house for less than $150,000. Okay? But at the end of the day, you're getting out from under that mortgage headache. That's why it's called a short sale. It's the bank that's coming up short. And again, Lonnie Miller does a lot of those. We may be able to get him up here at some point to talk about that. There's the deed in lieu of foreclosure, which is very interesting. It simply means taking the deed to your house and saying, okay, you take this, I'll be going now. You give them the deed, which is what they get at the end of a foreclosure process. You give it to them and you say, okay, I just saved you, 2 years in court, and now I'm off. Maybe you got transferred for work, maybe you got a job somewhere else, whatever. These last two, Chapter 13 and Chapter 7, obviously these are species of bankruptcy. And many people are afraid of the B word, which I understand. But the reality is the bankruptcy law, which is a federal law, it exists for a reason. It exists because sometimes circumstances overwhelm common sense and overwhelm your ability to work. Chapter 13 reorganization and Chapter 7 liquidation are areas I've been working in especially heavily for the past 10 years. And I can tell you, they work. They can work to help you pay off the mortgage, pay down the mortgage, get rid of a second mortgage permanently. This is something that you cannot do any other way, and keep the house. Like I said, we don't have the time to go into them in detail, but these are very real possibilities. And our next panel, which we hope to make the last panel for the evening, is what I refer to as mortgage modification and other myths. It's Halloween, scary. Mortgage modifications are kind of these Frankenstein monsters that, if you ask me, they don't exist. Let me tell you why. Everybody everybody has heard the phrase mortgage modification. So much so that, honestly, it's kind of taken on a life of its own. Falling behind on your mortgage? Mortgage modification. House is underwater? Mortgage modification. Sprinkler system isn't working? All right, well, maybe not that, but the first two. Here's the reality about mortgage modification and other techniques, okay? Technically, a modification is what happens after a temporary period of lower payments. The lower payment, which could result because the mortgage itself is being strung out or because the interest rate is being lowered, or technically because the bank has decided to reduce the amount of principal it expects, which is, you know, don't hold your breath. But the idea of mortgage modification is you get a temporary break, it becomes a permanent break. Okay? I'm not about to tell you that doesn't happen. It does happen, but the percentage of situations in which I've seen it happen is minuscule. Okay? Okay, if you're going to go through what we'll refer to as a modification, what forms could it take? Well, you have your principal deferral. This is very common, and especially common among you know, sort of solid middle-class borrowers who, it could be anything from they were out of town and they missed a payment to the dog ate their checkbook. It could be anything. This principal deferral is what I'm talking about. It's simply a matter of the bank saying, okay, you missed a payment, here's what we're going to do. We're going to throw it on the end. Just make your next payment. Exactly the same as the first one. Nothing's changed. It'll come out in the wash. Okay? Then you have your partial reinstatement, which means, okay, we know you're behind. And by the way, I should mention, I've had clients go through each and every one of these. We know you're behind. We'll give you 12 months to make it up. Or we'll give you, the maximum is 18 months. It's good because you don't need to get courts involved. You don't need to do anything extreme. But it's a burden. Okay, I mean, if your normal mortgage payment, let's say, is $2,500 a month, and you fall behind, oh, I don't know, 2 payments, that's an extra $5,000. You're going to have to spread that out over 5 months, 6 months, 12 months. You're paying up to $1,000 a month extra? Where's that coming from? Okay, so banks are not real generous when it comes to letting you make up a missed payment. But it's good to know that that's theoretically possible. That's partial reinstatement. Forbearance. This is actually what many people think about when they think of mortgage modification. They think of the bank, it's, for lack of a better description, simply letting them slide for a couple of months. Hey, you know what, guys? It's a bad time for me. You know, why don't you talk to me in 3 months and maybe I can pay you then. Forbearance technically means the bank allows an owner to skip payments or make lower payments. Beware. This is something we were talking about earlier this evening off camera. Unfortunately, it is a documented fact that many times when a bank says they will give you a forbearance or let you skip a payment or pay less than the full amount, that very underpayment, the one that they suggested, becomes their excuse for putting you into foreclosure. I realize this sounds crazy. It's like saying, hey, go pick that up. And when someone picks it up, you say, why'd you pick that up? Banks are doing this all the time. Forbearance, and of course, our favorite, true mortgage modification, a change in the terms of the original mortgage, usually the interest rate. This concludes the section that we're going to talk about in this session. I hope it's been informative. I want to thank my sponsors and my guests, and I want to invite you to contact my office at 630-378-2200. My name is Mazy. I'm a lawyer here in Romeoville, Illinois. I welcome your questions. You can also reach us by email at mhedayat, that's M-H-E-D-A-Y-A-T, at mha-law.com. Good evening. Welcome to Foreclosure Alternatives by the law firm of Hedayat Associates. My name is Mazy Hedayat. I'll be your host tonight, talking about the government's HAMP and HARP programs. With us this evening is Dave Johnson from Fidelity National Title, my beautiful office manager, Del Partovi, and on the broker side, Ellen Williams, a well-known name in Plainfield, Illinois, and especially on short sales. And I'm your humble host. Okay, so previously we talked about the steps involved in a foreclosure, how long they generally take, the various laws involved. We also talked a little bit about the terminology that you'd be hearing if a foreclosure were involved, and ultimately what steps to take during the foreclosure process. Now, long before foreclosure actually hits, you might want to take advantage of certain government programs. Unfortunately, there's a fair amount of confusion in this area, as programs such as the Home Affordable Modification Program, or HAM, or the Home Affordable Refinance Program, or HARP, are not mandatory. They're not government mandates to the banks. They're what you might refer to as suggestions with benefits. So banks get certain benefits from the government if they give homeowners a break using one of these programs. Pure and simple, this was part of the Obama wave of ameliorative statutes or acts intended to give people a break, but much like the TARP program that bailed out the banks, when banks didn't feel obligated to pass on the benefits to the citizens, they didn't. But nonetheless, these are real programs. They can work. Let's start by examining HAM, the Home Affordable Modification Program. The program was actually started by President Bush. Most people don't know that. And if you're out there, you're probably hissing right now when I say the word George Bush. But he started the program. It was continued by the Obama administration. It kicks in if you can show a financial hardship and you meet certain other qualifications. Now, one man's hardship is another man's real hardship. In this case, government hardship guidelines include these: sudden reduction in or loss of income, an unexpected change in household income, or household finances in general, which may mean higher expenses, an increase in monthly mortgage payments, an unavoidable increase in living expenses, as we mentioned, lack of cash reserves, excessive unsecured debt payments, in other words, high credit cards, and an involuntary work-related relocation. How's that for being forced to move? In fact, these are the things that most people think of as hardships. So if one of these conditions, or even something else, is having an effect on your ability to make a mortgage payment and pay your basic living expenses, here are the steps you need to follow. One, you need to determine, first of all, whether your mortgage is owned by Freddie Mac or backed by Fannie Mae. These are quasi-government organizations that were created in order to provide liquidity to the mortgage market so that banks, if they needed to, could sort of unload the mortgages, buy them back, and so on. They've worked great as far as organizations are concerned. In fact, Fannie Mae and Freddie Mac have become mortgage powerhouses, as one bank after another has either contracted or gone out of the mortgage business altogether. For example, Countrywide. Fannie Mae and Freddie Mac have stepped in to fill the gap, which has made them very powerful. So nowadays, a lot of people who think that their mortgages are not owned by Freddie Mac or backed by Fannie Mae, we find that they are. You need to find out, and to do so, you can contact us and we can provide a website you can go to, or you can simply contact your lender. So remember, that is the entrance requirement. If your mortgage is a Fannie Mae or Freddie Mac mortgage, then you can look at submitting the following documentation to your bank in connection with your request for modification. Proof that you have hazard and flood insurance, a property tax statement, pay stubs to show where you're at financially. You have to complete IRS Form 4506T, monthly household income, federal and state tax returns, a personal financial statement, which is like a cash flow statement, a list of your monthly household expenses, a list of all your assets, both tangible and intangible, and 6 months worth of bank statements. That kind of encapsulated what you'd have to do in the HAMP program. Of course, we haven't talked about what happens next. Suffice it to say, you're submitting these documents to your bank, and if anyone has ever tried to get a modification, even outside of these programs, you'll know that the process involves submitting, following up, often submitting a second or third time. In some cases, it seems like an innumerable number of times, but basically following through the process. Now, during this period, you're either continuing to pay your mortgage, or if you haven't been able to pay, you still can't pay. But nothing is going to change, per se. It's not as if once you're in the HAMP program, or at least you're applying for the HAMP program, your obligation to pay goes away or is reduced. Nothing happens. Then you have the HARP program, which is the Home Affordable Refinance Program. This is through Freddie Mac, one of those quasi-government organizations we talked about. This is interesting because it applies to homeowners who cannot refinance due to a decline in their home value, which has got to be just about everybody these days. It can lower your interest, which would result in lower payments. It can even result in lower principal payments, believe it or not, although only for a temporary period of time. It can also be used as a bridge to take an adjustable rate mortgage, and this is the so-called ARM that's gotten so many people in trouble, and replace it with a fixed rate 30-year mortgage, the old tried and true. As a net result, often what you're doing is you're enlarging the term of the underlying mortgage. Now, in an extreme case, you can look at California, which has an animal known as a roughly 100-year mortgage, or a 40-year. These are very large. Really, in the end, the consumer doesn't win, although the monthly payments will go down. You can finance through your existing mortgage company or through a different lender that is assigned by the program. So the HARP program and the HAMP program can both be useful. The HARP program probably more so for people who haven't had as many payment hiccups, are likely to be able to continue making payments in the future. The HAMP program might be more of a last resort. Eligibility for HARP, you have to own more than 80% of the property's current value. Excuse me while I laugh, because many times people are completely upside down. You must own a 1 to 4 unit home as a primary residence, your typical single-family home, or a secondary residence of about the same size. In other words, HARP can be used even when we're talking about your secondary residence or investment property, if you will. Again, it's very useful. If you own an investment property, you can't have more than 10 units. If you own an apartment building. Mortgage payments must have been made on time. That's why I say this program is more for people who are able to keep up with their payments. So your payments must have been made on time. The new mortgage that you might be flipped into can be an adjustable rate or ARM, but you're smart to go with a fixed rate loan if you can. And you have to pay down all arrears, that is to say all unpaid past payments, within 18 months. It's really about cash flow, folks. And if you're less than 2 months delinquent, so let's just say a 1 month hiccup, you can even take advantage of what's called streamline refinance. So, smooth sailing. Okay, so we've talked about the foreclosure process. We've talked about HAMP. We've talked about HARP. We've talked about what to do when you're in foreclosure. Those are very practical steps. Now, the next few things we're going to talk about are purely defenses to foreclosure, legal defenses to foreclosure. So this is not something that you're going to try on your own. Get a lawyer. One of the things you have to be aware of is force-placed insurance. This is something that escapes a lot of people. The fact of the matter is, if the bank, if your mortgage bank feels that you're underinsured, or if you actually let the insurance lapse, which frequently happens, the bank will simply place its own insurance on your property. And if you're trying to save that property, you're going to end up paying the premiums for that insurance. Now, most people say, well, big deal. Here's the big deal. Forced placed insurance, which is what this is called, is tremendously expensive. Some might say insanely so. Be aware of forced placed insurance. Be aware also that if property taxes have not been paid for a period of time, there's a hidden danger known as the tax sale. Taxes for real estate that have not been paid, and of course taxes here in Illinois have to be paid twice a year. Taxes for real estate that aren't paid can literally be paid by a third party. It's like somebody else paying your restaurant bill. When they pay it, they are then entitled to get that money back from you, plus an exorbitant amount of interest. And on top of that, the tax sale lien, which attaches to the property, is potentially more, has a higher priority than your actual mortgage lien. So number one, having a tax lien on the property makes your mortgage company very nervous. Number two, if you're trying to save the property, the HAMP program, the HARP program, or just trying to work with your bank, having a tax problem that could result in sold taxes or tax lien is one way to kill your negotiations right away. Lost payments. Who hasn't had these to contend with? When a loan is sold or transferred, not all payments are applied correctly. And over the past 5 years, this has been virtually epidemic. I mean, but it's hard to track, it's hard to prove, and often the results are going to bring you down in the eyes of your bank, even if it is their fault. Now, failure to accelerate the note. This is something, it resembles a game of chicken between you and your bank. Any mortgage process involves signing an interest in the real estate known as a mortgage and a personal obligation known as a note. It's the note and mortgage together that you sign. Well, virtually every note that you could sign in connection with real estate is going to say that the bank, the holder of the note, is entitled to all of its money if you miss so much as one payment. So think about it. Your $200,000, $250,000, $300,000 mortgage, you miss one payment, you got to come up with $300,000. Good luck with that. Now, what if your bank doesn't demand all $300,000 when you're one payment behind? What if it lets you get a payment behind, 2 payments, 3 payments? What if this all goes into the mix and you miss 1 out of every 3 payments for years? This happened to a client of March. The argument to be made on behalf of the homeowner is that the bank essentially waived its right to foreclose just because of a few late payments. Well, you let it go this far. Banks will be quick to tell you that failure to accelerate the note, failure to demand all their money at one point will not prevent them from demanding all their money at a later point. Of course, they keep the table tilted in their favor. Let's go to the next slide. All right. The rest of the items on this page are probably too far afield for us to really talk about in this forum. But suffice it to say, you can tell from what's here, and there are even a few more panels, that the deeper you go into the subject, the more there is to say. For those of you who've stayed with us through the prior portions of this presentation and were with us today, we thank you for your time and attention. Of course, copies of this presentation will be available via PDF to anyone who writes into us at mhedayat@mha-law.com. We'll be happy to provide that to you. And if you have any questions, you can always give us a call. We're right here in Romeoville. Beautiful, scenic Romeoville, I should say, at area code 630-378-2200. And I thank you.